What happens after court is often overlooked, but it can be just as important as the hearing itself. Whether you win, lose, or settle, lawyers need space to reflect, adjust strategy, and advise their clients on next steps. Debriefing helps you identify what went well, what could have gone better, and how to prepare more effectively for the next legal battle. Today, we'll learn the legal English to discuss outcomes, appeals, and evidence review with confidence and clarity. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community, support, and live practice, join us in our school community. The link is in the description. Today's lesson focuses on what happens after a court appearance and how to talk about it like a professional. Whether you're updating a client, discussing the strategy with your team, or preparing for appeal, you need to explain what happened clearly and accurately. We'll focus on high-level legal vocabulary like outcome, evidence, and appeal, and connect them to grammar tools like reported speech and the past perfect. These allow you to describe court events in detail, track what occurred and when, and communicate next steps in a structured, authoritative way. By the end of this lesson, you'll be able to hold confident post-court debriefs and reflect strategically on legal performance, outcomes, and future risks. What comes to mind when you hear the phrase court debrief? Maybe it's the moment you step out of the courtroom, adrenaline still high, and you need to explain to your client what just happened. Or maybe it's later in the day when you sit down with your team to review the arguments, the judge's comments, and whether it's time to appeal. Court debriefs are not just summaries, they are strategic reflections. You assess the outcome, analyze the evidence, and determine the next legal move. Let's activate your thinking with some sentence starters. I want you to complete them with your own examples. Let's start with the first one. One key point raised in court was that the opposing counsel failed to submit the expert witness report before the deadline, which weakened their entire line of argument. The judge had already reviewed the financial disclosures, so she dismissed the defense attempt to introduce new evidence on the client's income. After the hearing, we decided that pursuing an appeal would not be strategic given the limited chances of reversing the ruling and the additional cost to the client. These ideas will help you structure your thinking and prepare you for the vocabulary, grammar, and scenarios ahead. The verdict is the decision that determines the case's legal outcome. In criminal law, it's often guilty or not guilty. In civil cases, it might involve compensation, liability, or dismissal. For example, the jury delivered a unanimous verdict of not guilty. That one sentence ends the trial and shapes the next steps, whether it's closure, an appeal, or a press conference. In your post-hearing debrief, you might say, the verdict was fair, or we'll challenge the verdict based on new information. It's the anchor of the entire legal process. Cross-examination is where legal skill meets pressure. It's not just about asking questions. It's about exposing inconsistencies, challenging facts, and testing a witness's reliability. Let's say during cross-examination, the defense attorney challenged the witness's credibility. That one exchange could shift the entire tone of the hearing. Was the timeline unclear? Did the witness hesitate? Did they contradict themselves? A skilled lawyer uses tone, timing, and evidence to control the narrative, sometimes with just a few key questions. In debriefs, you might hear, his cross-examination turned the judge's perception, or we should have prepared our witness better. Not all evidence makes it to the courtroom floor. Admissibility is the legal gatekeeper. It determines what a judge or jury is allowed to see or hear. The judge ruled that the audio recording was not admissible. Maybe it was recorded without consent or obtained after a deadline. Even if it's true, it might be thrown out. In trial prep, teams argue over admissibility constantly. Did the evidence meet deadlines? Is it relevant, prejudicial, reliable? During your debrief, you might say, our strongest exhibit was excluded, or next time we'll challenge admissibility earlier. It's a technical term, but one with major consequences. Grounds for appeal. A trial's outcome isn't always the final word. When lawyers say they're considering an appeal, the first thing they look for is grounds for appeal, legal justifications for why the decision should be overturned. For example, the attorney cited procedural errors as grounds for appeal. That could mean a judge misapplied the law, allowed unfair evidence, or made a mistake in jury instructions. But not just any complaint qualifies. You must show that the error likely affected the outcome. In post-hearing meetings, lawyers ask, do we have solid grounds for appeal? Or was that ruling enough to challenge the verdict? It's a term that bridges the present with the future. A second chance, but only if legally justified. Judicial discretion. In many situations, the law doesn't give one exact answer. It gives options. That's where judicial discretion comes in. It's the judge's power to choose how to apply the law within a certain range. For example, the judge used judicial discretion to reduce the sentence. Maybe the statute allowed for 5 to 10 years, and the judge chose 5, citing cooperation or remorse. But discretion isn't unlimited. It must be justified, and it can be challenged if abused. During debriefs, legal teams often analyze, did the judge use discretion fairly? Or could that decision be appealed for overreach? It's a reminder that law is not only rules, it's also judgment. Procedural error. A trial is like a machine. It only works if every step follows the rules. A procedural error is when something goes wrong in the process. Evidence admitted incorrectly. A deadline missed. Jury instructions misstated. The case was overturned due to a procedural error during jury selection. Maybe a biased juror slipped through, or the defense wasn't given time to object. These aren't just technicalities. They can undo verdicts, trigger appeals, or damage a case's legitimacy. In a post-court debrief, teams might say, that was a reversible error, or let's document the procedural flaw for appeal. Small mistake, big impact. Let's start with a common courtroom moment. A lawyer tries to present a private WhatsApp message as proof of a threat, but the judge pauses. Was the message collected legally? Was the other party notified? Did it come from a verified source? These questions aren't about the content. They're about whether the court is allowed to see the content at all. What's the legal term for that decision? Admissibility. Admissibility is the legal filter for evidence. It ensures that only proper, lawful, and relevant material is considered during the trial. Imagine a family law case. The plaintiff's witness claims the other parent has never been involved. But on the cross-examination, the defense lawyer calmly asks about school pickup records and vacation photos. One by one, the details begin to contradict the original claim. The courtroom gets quiet, and the judge leans forward. What's the term for this moment when the other side challenges a witness under pressure? Cross-examination. It's one of the most strategic moments in litigation. Obviously, I said it too, and the answer, where credibility is tested and facts can unravel in real time. In a high-stakes criminal trial, the court clerk fails to swear in a key witness. No one catches it until after the testimony is complete. The error is documented. The jury delivers a conviction. The defense team prepares its motion. This isn't about facts. It's about the integrity of the process. What's the phrase for this kind of legal misstep? Procedural error. Procedural errors can lead to appeals, reversals, or even mistrials. The law isn't just about outcomes. It's also about the path taken to get there. After 3 days of arguments and 11 witnesses, the jury files back into the courtroom. The room is silent. The judge reads the words that end the legal process. When we find the defendant, those words carry weight. They bring relief, frustration, or next steps. What is the formal name for this decision? Verdict. The verdict is the conclusion of the trial, the court's final word on guilt, liability, or compensation. After losing a medical malpractice case, the lawyer reviews the trial transcript. She notices the judge had refused to allow key expert testimony and gave confusing jury instructions. The client asks, do we just accept the outcome? Not necessarily. The team drafts a notice to the appellate court. What's the phrase for the legal basis of their challenge? Grounds for appeal. Grounds for appeal must be specific, procedural, or legal, not just disappointment with the result. They are the roadmap to a second review. 2 defendants are found guilty of the same financial offense. One shows remorse, repays the losses, and cooperates with the investigation. The other denies responsibility and delays proceedings. Both face a possible sentence of 3 to 5 years. The judge evaluates the facts and gives one probation and the other prison time. What gives the judge that power? The answer is, of course, judicial discretion. And judicial discretion allows courts to apply the law fairly to individual cases, balancing justice with flexibility. In a legal debriefing, we often explain what was said in court, but we don't use the speaker's exact words. Instead, we use reported speech. This means shifting the sentence into the past, and often using the past perfect if the original sentence was already referring to a prior event. Let's look at some of these examples. The witness said she had never seen the document. This tells us she claimed something even before the hearing. The judge stated that the objection was overruled. Here, we remove the direct quote and make it sound more formal and neutral. Counsel argued that the contract had already been terminated. This makes the timeline clear. The contract ended before the hearing. These reporting structures are essential for updating clients, preparing appeals, or writing post-hearing memos. In legal English, timelines matter. When you're reviewing what happened before a court hearing, or even before a certain piece of evidence was introduced, you use the past perfect. The past perfect shows that one action happened before another past action. Let's go through each example. The witness had already signed the agreement before the lawsuit was filed. This makes the sequence clear. Signature first, lawsuit second. They had filed the complaint by the time we received the evidence. Again, one action, the complaint, was complete before the second. The judge noted that the parties had attempted mediation before trial. This shows that mediation wasn't just discussed, it actually happened earlier in the timeline. In court debriefings, this structure helps you reconstruct the case. It's essential for analyzing case history, explaining strategy, and laying the foundations for appeals or for future litigation. Let's put yourself in the role of the lawyer after a hearing. The client wasn't present and asks, what happened in court today? You need to sound professional, precise, and accurate with the legal timeline. Here's how you respond using both reported speech and past perfect. Opposing counsel said they had already submitted the motion. The witness testified that she hadn't remembered signing the document. The judge noted that the parties had completed discovery before the trial. Notice the structure. You're reporting what was said, and you're anchoring each action to the correct time in the legal sequence. These tools help you communicate clearly and confidently in professional legal contexts. Weigh the evidence. In courtrooms around the world, decisions aren't made impulsively. They're made by weighing the evidence. That means reviewing each witness statement, each document, each legal argument, and asking what's credible, what carries more weight. Imagine a complex fraud case. One side presents bank statements, while the other brings forward expert testimony. The judge doesn't immediately favor one side or the other. Instead, she spends hours analyzing the details, cross-referencing documents, assessing inconsistencies, and considering how each piece of evidence supports or weakens the claims. In her final ruling, she explains, "I have weighed the evidence and find that the plaintiff failed to establish liability beyond a reasonable doubt." This phrase reminds us that justice isn't rushed. It's thoughtful, it depends on careful legal reasoning, and that's what gives judicial decisions their strength. Call into question. In legal proceedings, credibility is everything, and when one fact contradicts another, or when new information surfaces unexpectedly, we may say that it calls something into question. Picture this. During a civil trial, a key witness testifies that he never met the defendant before the incident. But then a photo emerges, time-stamped and clear, showing both of them together at a prior event. Suddenly, the integrity of that witness's entire testimony is damaged. As the defense attorney argues, this photograph calls the witness's statement into question and undermines their credibility. Whether it's a document, a timeline, a statement under oath, when something doesn't line up, we use this phrase to formally introduce doubt. It's a powerful tool for challenging assumptions in court and a key part of post-hearing analysis. In court, words matter, but documents and formal statements only gain legal weight when they are entered into the record. Imagine a heated contractual dispute. Midway through the trial, the defense discovers a signed amendment that supports their version of events. It's not enough to simply mention the document. The attorney must formally submit it to the court and ensure it becomes part of the official transcript. "Your Honor," the lawyer says, "we ask that this amendment be entered into the record." This process makes the evidence official. Once something is entered into the record, it can be referenced in decisions, used in appeals, and preserved as part of the case history. It's a phrase that signals formality, procedure, and precision, all essential to sound legal practice. Stand up to scrutiny. In litigation, it's not enough to present a compelling argument. That argument must stand up to scrutiny. Picture a high-profile corruption trial. The prosecution lays out a detailed timeline, connecting bank transfers to specific meetings. At first, it sounds airtight, but then comes the cross-examination. The defense points out inconsistencies. A transfer date doesn't match the phone records, and a key meeting wasn't documented. In the end, the judge remarks, the timeline presented by the prosecution did not stand up to scrutiny. This phrase is often used in closing arguments or legal analysis to signal that something appeared strong on the surface, but didn't hold up under legal pressure. When preparing for trial or reviewing a hearing afterward, this phrase helps you reflect on what withstood challenge and what fell apart. Miscarriage of justice. Few phrases in legal English carry the emotional and professional weight of miscarriage of justice. Imagine this. A man spends 12 years in prison for a crime he didn't commit. Decades later, DNA evidence clears him. The original case was flawed. Evidence was ignored, the defense was under-resourced, and a critical testimony was never heard. A review panel states, this wrongful conviction was a miscarriage of justice. This phrase signals that something went deeply wrong, not just procedurally, but morally and systemically. It's used in appellate rulings, media statements, and judicial inquiries to acknowledge the legal system failed and that the consequences were life-changing. In courtroom debriefings, it reminds legal professionals why precision, fairness, and thoroughness are essential, because the stakes are never just technical. Tip the scales. In close cases where both sides present strong arguments, it's often a single fact, moment, or strategy that tips the scales. Imagine a business dispute. Both parties argue over a breach of contract, and the evidence is balanced. But then just before closing arguments, the defense introduces an email chain, one that clearly shows the plaintiff knew about the delay and approved it. That new evidence tipped the scales in favor of the defense. This phrase is used when a decisive detail shifts the balance, even slightly enough to change the result. It's often heard in strategic reviews that cross-examination tipped the scales or her testimony sealed the deal. In legal communication, it captures the idea that even one small move, if well-timed, can change everything. Let's imagine you're debriefing a senior partner after a heated commercial hearing. You begin professionally. The judge delivered the verdict just after 4 p.m. She stated that the defendant had breached the contract, but ruled in their favor on the damages claim. You go on. One key witness was called into question after we revealed an email that directly contradicted their testimony. During cross-examination, our team exposed several inconsistencies that didn't stand up to scrutiny. You clarify the timeline. The opposing counsel said they submitted the compliance documents, but we showed they'd failed to file them before the deadline. That became our strongest argument for grounds for appeal. You finished strong. Overall, the judge used her judicial discretion to limit late evidence, which we felt tipped the scales in their favor. We'll now review whether the procedural errors were significant enough to challenge. This is how you debrief with clarity, structure, and persuasive legal English, integrating vocabulary, advanced grammar, and high-level phrases into your personal communication. Now, let's take a moment to reflect on what you've mastered today. First, you learned precise courtroom vocabulary, the language used to describe outcomes, evaluate evidence, and raise issues in post-trial discussions. Then we focused on grammar, using reported speech to summarize courtroom dialogue and the past perfect to describe what happened before the hearing. We also explored powerful formal idioms like call into question and tip the scales, phrases that legal professionals use to explain outcomes, doubt credibility, or highlight strategic turning points. And finally, we put it all into practice with storytelling scenarios, helping you communicate clearly, confidently, and professionally in legal debriefings. Want to practice with real feedback? Join our full Legal English course and community with live classes and live webinars. The link is in the description. See you in the next lesson.